Welcome to the Business Law, Estate Planning, and Estates Podcast.
Hey everyone, welcome into an all-new episode of the Business Law, Estate Planning, and Estates Podcast with attorney Thomas LaPorte. I am your host, Mike Leon. Thomas here is the founder of LaPorte Law Group, PLLC, with an office out in Portsmouth, New Hampshire, and a location out in Andover, Massachusetts. They've got more than 30 years of experience helping individuals, families, and businesses owners protect their assets, their plan for the future, and navigate estates and business matters with clarity. Today's episode, we're going to be talking about the legal issues that come up most often for the businesses out in Portsmouth in the greater Seacoast region. Thomas, it's good to see you as always. Let me ask you about the businesses on the Seacoast region, because there's a lot that range from whether it be construction, manufacturing, technology, hospitality, all of those. So in your experience, what legal questions tend to kind of surface across these different industries?
Well, that's a good general question, Mike, and thank you for having me. I'll try to give a summary, somewhat of a comprehensive summary, touching upon some of the main issues. Different states have dramatically different wage and hour laws. Massachusetts has probably the strictest wage and hour act in the entire country. In fact, I know so. I was involved actually personally in the 2022 Reuter case, where treble damages were established as mandatory in addition to additional damages and mandatory attorney's fees. New Hampshire, for instance, the attorney's fees are discretionary and the multiple damages are limited at up to 10% per day, no more than double damages, again, within the discretion of the judge. Maine is more similar to New Hampshire than it is with Massachusetts. Each state, again, staying with the subtopic of employees, has different requirements for leave. Massachusetts has an earned sick leave law, now relatively new, but mandatory. Each state has different minute requirement breaks, for instance. So the employer has to be aware of the differences in the labor laws within each state, and there are also the Federal Labor Standards Act and the Civil Rights Acts at the federal level as well, in addition to other statutes. One is commonly known by many people, the Family Medical Leave Act. So if one has employees or is considering having employees, all of those should be learned, checked out, Department of Labor websites consulted, or seek out someone who is knowledgeable about these various laws, depending on what states you are working on. And one more thing I wanted to say, if, for instance, you're a New Hampshire employer located here in Portsmouth or Manchester or elsewhere, and you have employees in Texas, the company is subject to the employment laws of Texas, much like the other Texas laws that in effect that impact your business.
Well, that actually funnels into my follow-up, because I'm glad you mentioned about the Texas-New Hampshire difference there and which laws apply. So a lot of these local companies sometimes tend to use vendors or subcontractors or even, service partners across multiple states. So can you kind of explain a little bit more of the legal details that matter the most when businesses are operating or they're contracting within New Hampshire or perhaps a little bit beyond New Hampshire?
Sure. I'll give some examples. There are trucking companies. There are architectural companies that are licensed in different states. When one enters into a contract with a business partner, a vendor, material supplier, service contract with consumers and whatnot, the first thing that the local business, and I define that as within my jurisdictions, New Hampshire, Mass, and Maine. I have California, but I'm focusing on those three eastern states. You want to try to get the governing law of the contract to be your form state. There is a home field advantage. States don't like to admit it, but I have found over 30 years that states do tend slightly to protect their own. So the forum selection, as well as the choice of law, what substantive law is going to apply, you'd want to get that to be the state that you're headquartered in, if possible. Oftentimes there are arbitration clauses in lieu of litigation. I like to limit those as follows: that the parties can agree on a mutual arbitrator, but they do not have to select one from the American Arbitration Association or NJAMS. They're very expensive associations. However, the parties can agree to use their rules. There's nothing wrong with that. If there's a mediation provision, which typically comes before arbitration or litigation, which encourages the parties to try and work out the dispute through direct negotiation or mediation, we'll put a time limit on that mediation. 2 to 4 hours. You will know within the first hour or so if it's productive. That way you're saving money on the mediator, which is generally around $400 an hour, and make sure that the costs are split equally. Additionally, some parties try to argue that the winner gets its attorney's fees paid. I don't like that. This is America, not England. But if that is going to be a point of impasse, then I would recommend that the prevailing parties, meaning plural, because one there could be many issues, say 4 issues, and each party wins 2. Well, you're both prevailing parties. Those are some of the things with regard to dispute resolution. The other terms really apply to any contract, whether it's interstate or intrastate, and those are with regard to payment terms, termination, late fees, payment methods, things of that nature.
So let me ask you on that front, Thomas. Let's say somebody's listening to you right now. Their company relies heavily on service agreements, like maybe even solely. Licensing, design work, engineer, whatever it is. I've dealt with some of that in industries that I've worked in. So what kind of contract terms should they be paying attention to that are really going to require the most careful review?
The first and foremost contract clause that is applicable to service providers, and let's talk specifically IT or consultants that have their own business processes, design professionals, architects, is their intellectual property rights. More and more there is pressure, and over the years it has grown and become more commonplace. I'll give you an example. I had an independent consultant who was contracting with Pepsi-Cola. And Pepsi-Cola, of course, is a Fortune 500 multinational, has 17 companies within it of $1 billion in net worth alone. So those companies, and even smaller than that, try to commoditize the service that you were bringing, whether it's a drawing, whether it's software code. So intellectual property protection is most important. And there's lots of pressure to with a company that is hiring you for the service. That's where service as a software as a service rather came. Then you can enter into a license agreement that will continue on for a limited period of time. I would make it non-exclusive, so you're not exclusively in contract with this particular company. You can license your work to other companies you may consult with, and I would also limit their uses of the intellectual property. If it is a design, then they can use it to, which is what I usually draft. They can use it to maintain, improve the property. Say it's a dormitory at a state university that's being designed, but they cannot increase the footprint and they cannot use it on another building. So those are some examples. So I guess the short answer is the intellectual property rights of the service that they're providing. Mm-hmm. And the other thing is, the secondary things are, what is the standard of care that's going to be expected? So that should be drafted properly. If it's a construction company, usually there are building codes that can be referred to. So you want to make that standard of care as precise as possible. Sub issues of that are things that are beyond the reasonable control of the service provider you're not culpable for if something goes wrong. And these are things that are beyond the force majeure things, and that is a Latin term that usually refers to natural disasters, it's been expanded to include labor shortages, for instance. So things that a third party does that interferes with your ability to perform the service. So these things are some of the first topical issues, aside from payment and what happens when payment isn't timely, late fees, interest, those sorts of things. And then lastly, I guess to make a long answer complete, I guess the next major item would be indemnification and defense and hold harmless clauses. They all mean a different thing. And sometimes people lump them together or call them boilerplate. They're not. There's no such thing as a standard or boilerplate provision.
Right. Thomas, let me ask you about employee classification for a second, because, that's always a challenge for companies, right? Because you got traditional employees that are W-2, then you got remote workers, maybe you got some seasonal folks, contract work. So what issues do you see come up when the classification isn't handled correctly by the business?
That is a huge issue. That is a huge issue. More and more states' attorney generals, fair labor divisions, and states' departments of labor have tried to create, and they have in many, many states. I actually did a 50-state survey for for a company that does work in the 50 states and 2 territories. California being the strictest. Massachusetts is somewhat close behind it, but it has created a statute that says where the core of the business of the independent contractor, the so-called independent contractor, say you are a paralegal, Michael, or another lawyer, and you're doing some work for me, you are going to be deemed an employee entitled to benefits, the vacation time, civil rights protections. I'm going to have to pay payroll tax on you, workers' compensation insurance. So I am now indebted to you on many different levels, as well as to the state, because you perform a core service that my firm performs. So if a company is contracting with what they want to contract with, meaning an independent contractor, try to make sure that the independent contractor is also working for other masters, has other businesses that paralegal, for example, is working for. That way, he is not, or she is not exclusively dependent upon you, and is less likely to be determined to be a statutory employee. Other states have maintained the IRS standard, which really focuses around control. So what I mean by that is, if a company would like to avoid the additional expenses, which is about 30% more on average, and also the states get about 30% more in revenue from employees than they do independent contractors. They have more difficulty collecting payroll taxes and self-employment taxes and things of that nature. And a lot of single person entities, which are independent contractors, are exempt for workers' compensation laws. If they're an employee of a company, they are not. So the workers' compensation agency with state government gets revenue. So call me cynical, but there is a revenue grab component to all of this. But getting back to the control, if the employer can demonstrate, and labels and contracts are not enough, can demonstrate that the employer is not in control of the hours of the servant in the master-servant relationship, not in control of the techniques and how that person creates the service or the work product, transportation, tools and implements that are used are owned by the servant rather than the master. Those are all indicia that the employer, or the so-called employer, is not in control. So that servant would more likely be deemed to be an independent contractor, which is less costly for a company.
Let me ask you about insurance and an understanding of insurance, because a lot of owners, they want at least some high level understanding of that. What types of coverages should businesses be asking about, especially experienced commercial insurance agents that they talk to, so that they're aware of the industry specific risks? Excuse me.
That's a great question. And you mentioned commercial insurance agents, commercial lines insurance agents. One really ought to look around ask around if one doesn't know of a good agency that has connections to, I know a person here in Portsmouth that has connections to 70 different commercial lines carriers. So he gets the best coverages available for what I have seen for the best value or values, or as near as possible. But the types of coverages would be first and foremost general liability, particularly if one has a brick and mortar institution. It's a laundromat, people are coming in. There could be wet floors. General liability to protect those persons that are in your building. It will also cover other perils besides injuries. It'll cover property damage, things of that nature. Workers' compensation that I alluded to earlier. For construction companies, is builder's risk insurance that should be looked at, because sometimes things get loose and blow and damage property. That is a specific type of coverage that needs to be contracted for separately. Cybersecurity risk is a big deal these days because of all the hackers that are getting into employers' accounts as well as their clients' accounts that may be on the employer's servers. Employment practices liability is another issue that is more commonplace now because of the prevalence of claims. And there are legitimate civil rights violations and discrimination and harassment that's out there, but there's a lot of specious fraudulent claims as well. So that insurance will help you pay to defend against those type and or help settle, as many of them do settle. Yeah. Those are some of the types of coverages. Vehicles, trucking companies, you've got to get commercial vehicle policies as well. So,
Thomas, thanks for your time and insights covering all of this today. I truly appreciate it, my friend.
I enjoyed it too. Thank you, Michael.
And thank you to everyone out there for listening to this installment of the Business Law, Estate Planning, and Estates podcast. If you want to learn more about the work that Thomas and the team do over at LaPorte Law Group, do me a favor, visit laportelawgroup.net right now. Don't forget to like, subscribe, leave a review, and comment or share the episode with someone who needs to hear it. I am Mike Leon. We will see everybody next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.